Welcome back to Winning Isn't Easy. Let's talk about how taking care of your spouse can destroy your mental nervous disability claim. So, do you have anxiety, depression, post traumatic stress disorder? Have you applied for your short and long term disability benefits? Did you review your medical records before you submitted the claim? Do you know whether your mental health provider supports your claim? And if not, there can be big problems ahead. So, let's talk about crucial mistakes that you can make in a mental nervous disability claim. When you apply for those benefits, the carrier or the plan administrator is going to obtain and review your medical records. They're going to ask your medical provider to complete forms such as a behavioral questionnaire. And what are they looking for? Well, what they're looking for is the history of your symptoms, the onset of your symptoms, any employment related causes for these symptoms, any family related causes for these symptoms. They're going to be looking for a description of how your symptoms impact your daily functioning. They're going to be looking at your level of social functioning. They're going to be looking at the results of mental status examinations conducted by your provider. And guess what? They're going to ask your treating provider to describe your condition, your social functioning, your responses to medication, and any test results. What's in your medical records and what your provider writes on those attending physician statement behavioral forms can heavily influence whether your benefits are approved or denied. So let me give you an example. Let's talk about the case of Rubin versus Life Insurance Company of America. Now, this is an 11th Circuit case. I'm in the 11th Circuit. The 11th Circuit is a bit conservative, so you need to obviously understand your circuit's proclivities in an ERISA claim so you understand how they're going to look at an appeal. In this case, Ms. Rubin was a telephone sales representative, and she stopped working in 2021 because of depression and anxiety. She applied for her short-term disability benefits, which were denied by Lena, and her treating psychologist described her social functioning as improved. That didn't help. But the psychologist also attributed her inability to work to her need to take care of her husband. The psychiatrist agreed that she couldn't work, but didn't explain how her depression and anxiety prevented her from working, apart from, of course, her caregiving responsibilities. And this was a costly mistake because the carrier's physicians concluded that her medical records didn't show a psychiatric impairment. Her mental status exams were normal. And I will tell you, I hate the many mental status exams that psychologists, social workers, psychiatrists use because they really are generally normal. But that normal mini mental status exam doesn't reflect the degree of your functioning, which, in my view, is really the crucial issue here. And the problem also in this case was that the medical records didn't provide any clear evidence of her functional limitations as a result of her anxiety or depression or whatever problem she was having. Was she having any problems interacting with her family members? Was she having any problems interacting with the public? Was she having difficulty following instructions? Did she have problems with isolating herself, with lack of self-care, with feelings of guilt or self-worthlessness? And how did all of those symptoms impact her ability to function? But in this particular case, her caregiving role suggested functional capacity. And guess what the carrier did? Their medical director, a psychiatrist, spoke with Rubin's treating psychologist in a peer-to-peer call that only reinforced these impressions. The treating psychiatrist also confirmed that Rubin could care for her husband and could not provide examples of tasks that she was unable to perform from a psychological standpoint, notwithstanding she could provide care for her husband. The records showed she had been overseeing a condo renovation and had been going to the gym, which were activities in the carrier's view that indicated no psychiatric impairment. And I would probably agree. Look, if you're interacting with workers who are general contractors and subcontractors on a condo renovation, you're interacting with people, you're making decisions, you are basically probably having more than adequate social functioning. Same way with going to the gym. unless, of course, you were having a problem with the members of the gym, which was not documented in the medical records. So Rubin lost in federal court, and ultimately an 11th Circuit appeal was taken. The 11th Circuit in this case used the de novo standard of review, which means they could substitute their judgment for that of the federal judge. And even with that favorable standard of review, the court agreed that the decision to deny the claim and terminate benefits was reasonable based on the evidence. Now, what was worse is that she had the chance to respond, but didn't do so in a meaningful manner. A stronger approach would have been to submit sworn statements describing her daily limitations, having her husband give an affidavit and statement about how she had trouble with the caregiving function from a psychological standpoint, and also how her caregiving role affected her functioning. Have her family and friends who may have observed her address those particular issues, particularly going to the gym or interacting with the contractor. She may have had trouble interacting with the contractor, but who knew? And of course, the carrier drew speculative conclusions that helped their case. And obviously, her psychiatrist should have addressed these issues in a meaningful fashion. You have to understand that providing care for a spouse can be inconsistent with disability allegations, and particularly the activities that she did with regard to the condo. The medical documentation has to address how you can do these things, but still remain disabled and unable to do your own occupational duties. So when you're filing a claim for a mental nervous condition, you need to make sure that your provider is explicitly connecting your symptoms to your inability to perform your occupational duties, not just to life stressors or family demands. It's the clarity and medical specificity can make all the difference between an approval, a denial, and a termination. Got it? Let's take a break.